In response to the lawsuit, Governor Matt Bevin, who had succeeded Beshear, issued an executive order establishing a revised marriage license that didn't contain the county clerk names. Great. I actually think it's a pretty good solution. Someone tried to find a way, even though many of us were, very righteous about the situation, still sometimes when there's a movement like that and it's not prejudicial, it doesn't say down with gay people or something like that. When it's not prejudicial like that, hey, that's great. They found a solution that didn't involve making things worse.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
Hello everyone, I'm Leonard French, your favorite boat-residing copyright attorney. We're here in Rotterdam on our trip to move Kaylee to Luxembourg. And I wanted to bring you a fresh video because some things happened last week, as they always do. And I wanted to tell you about Kim Davis, because this is really remarkable. And you might have been confused, like I was, over why there were two different reports. Some of them kind of didn't notice the other one. Some reports were that somebody has to pay attorney's fees, and it's going to be the state of Kentucky. And then someone denied qualified immunity to Kim Davis. Well, wait a second, wouldn't a denial of qualified immunity mean that she's not immune to the suit? So then why did they not get the attorney's fees? Well, they're two different cases. So we're going to go over both. And I'll see if we can't edit them together to kind of make one coherent video about it. So this is going to be fairly short as Lawful Masses videos go, because I am in an unair-conditioned cabin and we are experiencing 32 degrees Celsius, 91 degree Fahrenheit temperatures outside. So I have literally an evaporative cooling system trying to keep this room cool. And if you watch me carefully, you'll probably see me start dying as we get further and further into this. So I apologize for that in advance. So this first case is the one, actually no, let's take a look at the attorney's fees case first. I think it'll work better if we go in this order. This first case will be the attorney's fees case, and this will be the case of April Miller, Karen Ann Roberts, Chantel Burke, Stephen Napier, Jody Fernandez, Kevin Holloway, Aaron Skaggs, and Barry Spartman versus Rowan County and Eldwood Caldwell. Kim Davis's name really isn't on this as much anymore, and you'll see why. Under the American rule, which is the name for the attorney's fees shifting provision, parties typically pay their own attorney's fees. The English rule, I believe, or European rule, is where the losing party pays in just about every case, unless there's an exception, whereas the American rule is each party separately pays unless there's an exception. Congress created an exception, though, for plaintiffs who win cases against government officials over civil rights violations, 42 U.S.C. 1983, and I think there's a few other laws in there. Here, plaintiffs applied for marriage licenses only to find that Kim Davis, who oversaw marriage licensing for Rowan County, Kentucky, wouldn't issue them. So they sued her for infringing their constitutional right to marry, and the district court ordered Davis to give them what they wanted. Once they obtained licenses, they chose not to pursue the lawsuit any further. So there was no further lawsuit, but they did pursue attorney's fees, which the district court awarded and then required the Commonwealth of Kentucky to pay. The Commonwealth and the official who replaced Davis now contend that the plaintiffs didn't win and thus can't recover attorney's fees. They also dispute who must pay the fee award, and Davis's successor challenges the amount of the award. We reject all the issues the parties raise on appeal, and we affirm. In the summer of 2015, Kim Davis was the county clerk for Rowan County, Kentucky. One of her responsibilities was to issue marriage licenses, but same-sex marriage offended her religious beliefs. So when the Supreme Court recognized a constitutional right to same-sex marriage in Obergefell v. Hodges, the 2015 decision that made marriage legal for everyone, we no longer have to call it a civil union or separate but equal or 3/5 of a person. We can now say that everyone anyone can get married, and you don't have to qualify it with whether a person has rights or whether a person is less of a person. So that was one of the things I was upset about, is I identify myself as part of the LGBTQ community, and to have someone tell me that if I chose to marry someone of the same sex, that was somehow different than if I loved someone of the opposite sex. I didn't see a difference for me, so it was a little bit offensive. Well, it was quite a lot offensive for a person who didn't understand my perspective to tell me what my perspective was and tell me that I had fewer rights than they did. That seems to be a running theme in our society these days, and one of my life's goals is to exert constant assertive pressure to help make this the end of that era, although the other skeptical part of me is skeptical that human nature is what it is, and unless there is some fundamental change to human nature, there will always be this kind of bigotry and hate. One day after the Supreme Court released the Obergefell decision, Davis stopped issuing marriage licenses. She didn't discriminate against same-sex couples, though. She stopped issuing licenses altogether. That meant that when plaintiffs, same-sex couples and different-sex couples who lived in Rowan County, sought marriage licenses from the clerk's office, they couldn't get them. With a constitutional right to marry, yet no ability to obtain marriage licenses within the county, plaintiffs sued the county and Davis personally, and in her official capacity. They sought injunctive, declaratory, and damage relief. Plaintiffs promptly moved for an injunction. The morning after the Supreme Court rejected Davis's request for a stay, Davis decided to resist the injunction. She told her deputy clerks to continue enforcing her no-license policy. Two of the plaintiffs again sought a marriage license but were rebuffed. Plaintiffs then moved for the district court to hold Davis in contempt of the injunction and to expand the injunction's scope to prevent Davis from enforcing her policy against other couples. The district court did both. And after Davis's deputy clerks told the court they would issue marriage licenses, the court gave Davis a second chance. If she would agree not to interfere with her deputy clerk's compliance, she wouldn't be sent to jail. She chose jail. While Davis was in custody, two plaintiffs decided not to issue marriage licenses again. 6 others sought and received them, and 4 of those 6 used them to wed. After learning of plaintiffs' successes, the district court lifted the contempt sanction and released Davis from custody. It ordered her to refrain from interfering with her deputy clerks as they issued licenses. In addition to fighting the case against her, Davis brought a case of her own. She filed a third-party complaint against the governor of Kentucky, Steve Beshear at the time, and the commissioner of Kentucky's Department of Libraries and Archives, Wayne Onsk. She opposed same-sex marriage on religious grounds. The marriage licenses she issued had her name on them, and she felt that her name's appearance was the equivalent of her personal endorsement, as opposed to her official elected capacity. Remember, she sought to be an elected official. She sought the votes of her constituents. So the fact that her name is on the licenses is because she chose to be there. She sought a preliminary injunction requiring the Kentucky officials to exempt her from having to issue marriage licenses. In response to the lawsuit, Governor Matt Bevin, who had succeeded Beshear, issued an executive order establishing a revised marriage license that didn't contain the county clerk names. Great. I actually think it's a pretty good solution. Someone tried to find a way, even though many of us were, very righteous about the situation, still sometimes when there's a movement like that and it's not prejudicial, it doesn't say down with gay people or something like that. When it's not prejudicial like that, hey, that's great. They found a solution that didn't involve making things worse. And the clerks are no longer required to sign marriage licenses, so the name and signature don't even need to appear on there. Those changes appeased Davis, so she asked us to dismiss the various appeals then pending in our court. We granted her request and instructed the district court to vacate its preliminary injunction. On remand, the district court followed our instructions and also dismissed plaintiffs' damages claims on its own, or sua sponte. But plaintiffs chose not to appeal the dismissal of their damages claims, but they sought attorney's fees under 42 U.S.C. 1988. The district court awarded plaintiffs $222,695, but imposed the liability on the Commonwealth, not on the clerk's office. That prompted the Kentucky officials, who hadn't responded to plaintiff's motion for fees, to ask the district court to amend its ruling to assess the fees against the clerk's office. The district court refused. The Kentucky officials and Davis appealed. After the parties submitted briefs, attorneys were replaced, and they adopted the same arguments. The common law contains no right to attorney's fees for the winning party. Instead, under what is known as the American rule, each party pays his, her, or its own fees unless a statute explicitly provides otherwise. Here, 42 U.S.C. 1988 provides, in any action or proceeding to enforce a provision of Section 1983, which was the civil rights law I was talking about, the court, in its discretion, may allow the prevailing party other than the United States a reasonable attorney's fee. Whether plaintiff may obtain attorney's fees then hinges on whether they prevailed. Caudle and the Kentucky officials say they didn't. Plaintiffs say they did. And if they did, the officials argue over who must pay the award. They point the finger at each other. We must resolve a split in our case law, so they're going to do that first. Sometimes they've reviewed under a clear error standard, sometimes it's a de novo standard. And let me see which one they're going to go with. And they're going to officially adopt a de novo standard of review. So they're going to review these kinds of claims brand new from the beginning. The district court issued a preliminary injunction and shortly thereafter dismissed the case as moot. So that injunction was all plaintiffs got. In such scenarios, we apply a case-specific inquiry, which we approach with both hesitancy and skepticism because the preliminary nature of the relief generally counsels against fees in the context of preliminary injunctions. And we look for a court-ordered, material, enduring change in the legal relationship between the parties. A few aspects of this inquiry warrant further elaboration. First, for the change to have been court-ordered, the preliminary injunction must have caused it. It can't stem from Davis's voluntary modification of her conduct. Second, for the change to have been material, it must have directly benefited plaintiffs by altering how Davis treated them. And third, for the change to have been enduring, it must have been irrevocable, meaning it must have provided plaintiffs with everything they asked for. Some examples help make the abstract concrete. Good language. When protesters seek an injunction to exercise their First Amendment rights at a specific time and place, say to demonstrate at a Saturday parade, a preliminary injunction will give them all the court-ordered relief they need and the end of the parade will moot the case. The same is true of a government employee who seeks to exclude an unconstitutionally obtained report from an administrative hearing and obtains a preliminary injunction that irrevocably excludes the report. So also for a plaintiff who seeks to delay enforcement of a statute until a certain event occurs, say a scheduled public referendum, and the preliminary injunction brings about that result. Here, what happened doesn't fit neatly into those examples. Plaintiffs, unlike the hypothetical protesters or government employee and public referendum enthusiasts, didn't seek relief specific to a time and place, but that's a distinction without a difference. Because 1, Kentucky marriage licenses gave couples a 30-day window in which to wed, and 2, couples can obtain licenses at any time, and 3, those licenses are one-time things for all but the dilatory or wishy-washy. Put differently, plaintiffs needed only the opportunity to obtain marriage licenses because Kentucky law left the rest to their discretion with licenses in hand. The plaintiffs could choose the time and place to wed. The preliminary injunction then rendered plaintiffs prevailing parties. Their relationship with Davis was one of licensee and licensor. Before the injunction, Davis refused to issue marriage licenses, but now the injunction required her to. So, in short, the injunction gave plaintiffs all the court-ordered relief they needed, and the issuance of the marriage licenses mooted their request for them. So the court is going to go on, and I really want to get over to the one where we deny Kim Davis qualified immunity, and that's another 13-page case, so let's just skim here a little bit. They go into the details here of saying who was responsible for what and when, basically, and whether or not the parties who eventually got their marriage licenses could be considered prevailing parties or not. So the court concludes that plaintiffs should recover their attorney's fees and then goes into who should pay them. And the logical answer is the party against whom they prevailed. The district court enjoined Davis in her official capacity, and that is now a role that a different clerk, Caudle, plays. So does Caudle the clerk, have to pay for Kim Davis, the former clerk's, misbehavior? No, not necessarily, the court says. They go over case law. The Supreme Court adopted a binary choice in Hutto v. Finney. Either the official in the official capacity pays the fees from funds of the agency or government under his control. This is so regardless of whether the government is a party to the lawsuit, but Hutto doesn't tell us how to choose between these options, and the Hutto court faced a choice between individual officers or the government they served, and the court never determined how liability could shift among three possible parties. In the absence of guidance on when to shift liability up the chain, the district court looked to the entity on whose behalf Davis acted when issuing or refusing to issue marriage licenses. And to decide which entity that was, the court invoked a 6-factor test from the Krabs v. Scott Sixth Circuit case, 2015. Those 6 factors are the state's potential liability, how the state statutes and courts refer to the officer, who appoints the officer, who pays the officer, the degree of state control over the officer, and whether the functions involved fall within the traditional purview of state or local government. We agree with the approach, and they adopt it with one modification. The court basically says that Kim Davis was acting in her official capacity, and the plaintiffs prevailed against the state and Davis in her official capacity, and they didn't make other arguments for obtaining other relief. So instead of applying the liability on the clerk's office directly, the court will impose liability on Kentucky because Kentucky required Davis to issue marriage licenses to eligible couples. The parties have cited no authority suggesting that if a county official acting on the state's behalf fails to do a job the state requires her to do, that failure creates and confers discretion the state never gave her. Davis's refusal to issue marriage licenses then doesn't mean she acted on behalf of the clerk's office, it means she acted on behalf of the state, because it was a state law that she was enforcing, not a county rule. So that seems to be what that's about. So they say the same thing. Thus, because Davis acted on Kentucky's behalf when issuing or refusing to issue, the district court correctly imposed liability for the award on the Commonwealth. They challenged the attorney's fees amount, and let's see what the court says about that. They don't make the appropriate appeal argument, so it doesn't matter, and the court will affirm the $222,000 695 fee award. Now, that's just the one case, and that's actually not the more interesting of the two cases, I don't think. So let's go over now to the David Ermold and David Moore case. Thank you for joining me for this floating edition of Lawful Masses. I am Leonard French, your favorite copyright attorney. Thank you to Joshua Davis, who is sponsoring our videos for July and August on behalf of his service from TandaPay, which is a blockchain-based social insurance program. I am working on a video for him. If you guys know me, I'm making a mountain out of a molehill. I want to make a really good video for him, which is why it's not out yet, and I'm really sorry that it's not out yet, and I do owe Mr. Davis an apology for that, but it will be out shortly. As soon as I get myself established in Luxembourg, I will be working on that straight away, finishing that straight away. So thank you to Joshua Davis and TandaPay for your support these past 2 months at that level. We will be along very shortly. Thank you to our $50 plus supporters, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Jan Negrey, Blackleaf, Spirit Bear, Daniel Perez, Snorre Wisotzky, NotMike, Joe Tyson, and King Macro. And thank you to everyone in the description, the $5 plus supporters and other supporters as well. You're all very much appreciated. This show would not be possible without your support. Please, please pay attention. Like and subscribe and share. And if you want to, also support us financially. I put the money from this back into more stories. We are getting ready to take Brandon on full time, and I would like to start paying Tactical as well for research and writing. So if we can have your support for that, I promise you from the bottom of my heart, you will not regret it. We are using these funds to build the channel And by the end of the year, I intend to file, probably by the end of September, I intend to file the 501c3 paperwork to turn Lawful Masses into a charitable organization. Again, it is not there yet, and any money you're donating is not a charitable donation, and we are a for-profit organization. But we are building something out of this that is going to make the world a slightly better place. And if we can do better than that, that would be awesome too. And we will do it with your help and our efforts, and we really appreciate that. So thank you for looking out for us. We will always look out for you as we can. I am Leonard French, your favorite copyright attorney. I'll see you in the next one. Love you all. Bye.